Everyone, Ian Andrews, I'm the Executive Director with LakewoodAlive. Thanks for being here. We really appreciate it. We're at 10:03, so let's get started. We're pleased that you're joining us today for our Commercial Leases, a legal guide to protecting you now and in the future, a webinar that we've been talking about for quite some time, and we're really thrilled to have our expert attorney joining us here. So we're going to get started in just a moment. Briefly, we're going to run through some of the programs that LakewoodAlive has been partnering with the city and the chamber on since what is now close to 4 months of this pandemic, which is really hard to believe. We will meet Meg Cooper, who's going to lead us through the presentation today. The questions and answers, please ask your questions throughout. There's a little thought bubble that you can type in your questions. I'm joined by my colleague, Allison Urbanek. She is our Housing and Internal Operations Director. And Allison will monitor the questions. And then if you have something that you see as Meg's going through the presentation, please ask it. And then Allison will help to get those questions asked. We can get an answer for you. So Allison, thank you for your help today, and thank you for being here with us. Going into programming, as a nonprofit community development organization, our mission is to foster and sustain vibrant neighborhoods. And part of that is ensuring that we have vibrant commercial corridors. This is now the 8th we hosted a webinar prior to April 1st, and now we have this will be the 9th with a series, Knowing Your Home series, for tonight. So please.
Hey everyone, this is Allison Urbanek with LakewoodAlive. We are experiencing some technical difficulties, so we're going to place you on hold for just a moment, and we'll be back with this webinar in just a minute. So if you can hear me, if you could please put your hand up. You can see that on the right side of your screen. It's about halfway down. Just raise your hand if you can hear me. I would really appreciate that. That will help us. And then as we are trying to fix this technical difficulty, we will be just taking a brief pause, and we'll be getting back with you in just a moment. Cool. Thanks for all those hands. I really appreciate it. Okay. So we're just going to put you on a brief pause here. Thank you.
Okay, hi everyone. Can you hear me? Meg, is that sounding better? Because I'm really sorry that we're having some issues with the phone. Meg, I've unmuted you, so if you just want to chime in, can you hear me better now?
I can hear you better, Ian.
Okay, great. Sorry, team, but thanks for your patience. So we went through just some of the small business support. We're going to continue on, so we don't want to take up any more time. I want to get to Meg, but we appreciate everyone's support in helping us be able to accomplish a lot of these bullet points. So Meg, attorney Margaret Cooper of Margaret Cooper LLC is with us today. So Meg, if you just want to kind of give a brief introduction.
Hi guys, I'm excited to spend the next hour with you. So honored to be with Ian and Allison, that they asked me to be here, LakewoodAlive. So I was admitted to practice law in 2000. I've practiced real estate, business law, self-storage law, consumer law, lemon law precisely is where I got my start. I still practice consumer law, and the main, I guess, thrust of my ability as an attorney is to bring parties together to work together. So this was a natural when Ian called me, because I really feel that this COVID crisis and now the riots have made it so that my job has been to negotiate between landlords and tenants to bring everyone together to understand common issues on both sides and make it work for both parties. So that's my area of expertise. When all breaks down, of course, I am a litigator at heart and am not afraid to step in a courtroom. So, well, since COVID, maybe a little, but it's been an amazing process and I love what I do. So I cannot wait to present to you. Thanks, Ian.
Great, thanks, Meg. I appreciate that. So we're going to just dive right in. So let's get this going here. So Meg, if you want to take it away, and then let me know when you want to advance a slide. Just say next slide, I'll move it forward. And then as Allison gets questions, we'll make sure to pass those along to you, okay? So go right ahead.
Okay, so we're going to talk today about protecting you specifically in your business. And we're going to look now and what the leases may look like in the future. So in Ohio, there's $2.4 million 2.4 million commercial properties. So in Lakewood, there's 5,318. Now I know that 0.02% looks really small, but I got to tell you that Ohio has 44,000 plus square miles of land. Lakewood's only 6.69 square miles. So Lakewood is only 0.0001% of the size of Ohio and has 0.02% of Ohio commercial properties. So that's a pretty high number in a small, in a 6.69 mile, 6 square mile concentrated area. So Lakewood is heavy with commercial properties. Next slide. So when you start looking at how commercial properties are treated, courts treat commercial and residential properties very differently. So residential tenants have statutory rights and legal protections. Commercial tenants' rights are only limited to what's set forth in the lease. So you have to be really careful to understand what you're negotiating and what you're signing. There's no standard forms of a commercial lease, so they're much more subject to a back and forth dialogue between the landlord and you. Keep going. So the most common commercial lease is the gross lease, but a triple net lease is something probably a bigger business would have, and that is like the tenant, you own the building. So you have to pay all the rent, all the utilities, all the property taxes, all the business insurance, and that's like you own the building. Then there's a double net and a single net. I'm not going to get into those because the most common leases, which probably you fall under, are the gross leases, where you pay common area maintenance and rent, and sort of all the rent, utilities, and operating costs are apportioned in there, but it's much more easy to budget for you because you know exactly the amount you're paying and you're not going to worry about fluctuating taxes or building insurance or these types of things, utilities. So there's also a modified gross lease, and that is much more negotiation back and forth of terms and what you need to protect your business. Next slide. So in a gross lease, which is the one that's most common, you agree to pay a gross price per square foot. And landlord has kind of wrapped those other things that are listed there that you can read. They're included in the total rent. Most leases have an escalation clause on either the gross or the net rent amount. Now that said, that escalation shouldn't be a really high amount. It should be commensurate with the type of building that you're in. Buildings have ratings. There's A buildings, B buildings, C buildings, D buildings, and Those are, you know, an A building might have a 2.5% increase every year. A C building might have a 1.5% increase every year, but that's up to your attorney to know and negotiate on your behalf, or if you have access to that knowledge for you to negotiate. Next slide. So modified gross lease is a gross lease with modifications. So the landlord and tenant dicker back and forth and they say, you get this, I'll get this. Like, I'll do the electric, and landlord, you get everything else. You get water, HVAC, you have to take care of the building, et cetera, et cetera. So this is where an attorney is really helpful, because sometimes when you get caught up in what you're paying, it's really a rough go in negotiating with a landlord who has been doing this for a while. Next slide. So lease provisions, there's provisions common to every lease, and I'm going to address that shortly. I'm also going to present new provisions that maybe if you're signing a new lease related to COVID-19 and related to things going on in the world, it would be advisable that we didn't think about before, but probably would protect you more. And I'm going to put recommended provisions that you should probably, you know, there's tips here and there that you should negotiate into a new lease.
Hey, Meg, I have a question from Carlos. He wants to know, so to the previous slide, about how do you know what your building is rated? You know, you were talking about the different types of buildings. How does someone know what kind of building they're operating out of?
So if they are working with a commercial broker and someone that's assisting them in finding that space, that commercial broker has access to a network that will tell that broker, who can pass along that information to the tenant, what type of building it is. But other than that, I guess searching the internet, I don't think you'd have access to that information on your own. You'd have to work with a broker.
Okay, great. And anyone who is in our business district or in Lakewood, actually, let me take that back. Anyone in Lakewood, if you have questions about that and you're not sure, you know, Ian and us here at LakewoodAlive would be happy to help you out with that. I do have another question. It's from Jeff. It says, CAM or CAM seems to be a constant battle for us. Our leases generally vague on what maintaining the common area entails, so our landlord does the bare minimum. What is the legal minimum that is required of landlords to consider an area maintained?
So in a commercial lease, you have to look to the terms of your lease. And if it says it has to be reasonable, it has to present well, and it can't be there causing a danger for invitees or people who are coming onto the premises to visit your business. So if it's not reasonable, you can certainly raise that to the landlord in writing, or whatever form you chose to communicate, if it's email, text, whatever the case may be, but it should be a written format. And reasonable means that it should look appropriate for the building. And if it's not commensurate with that, that should be raised with, if there's a building code in the city, you call the city hall and you explain what's going on. You say the lease requires that it should be reasonable, and it's not. And I need an inspection, and maybe they'll issue a ticket, or maybe they'll issue, you know, some sort of notation on the property and say that it has to be fixed. Just like when lawns get too long and they charge you $200 to cut it, the city, it's the same kind of thing. You can report it to the city and they have to take care of it.
So for this person, for this building owner, I think that they really struggle to do the minimum for a lot of things in the building. So if it's like, for instance, the cleanliness of bathrooms, that would probably be a health department thing, maybe it's a city thing, I'm not sure. But is there any like way of putting stuff into escrow for building as a business owner, like a residential person could do if, let's say, their building was not being maintained?
Okay, so first you have to look to the lease. Is it for the tenant to maintain the bathrooms in the common areas? Are they supposed to hire the cleaners? If not, then the terms of the lease, if they don't speak to that, that's an issue, because it's going to be hard. If it's a sanitation issue, yes, it should be reported. You can't have, it's an unsafe issue, and the lease can probably, depending on how bad it is, could be terminated for that. But it would have to be well documented, well reported numerous times, etc. And keeping a journal in that scenario and pictures is really, really integral.
Great. Cool. Thank you.
Yeah.
We're all caught up with questions right now, so if we want to continue with the presentation.
Cool. All right. Oh, go back one slide. I think there was isn't there a lease? Oh, I guess I deleted one of the something. So we were going to get down to commercial leases, and the first thing is actually, I guess, I don't know what happened to the slide, but it talked about the parties. And I just want you to know that signing in your personal name on a lease means that you're personally liable, and they can come after whatever property you own. If you don't pay and you go into default, they can come after your, if you don't have a lien on your car, you own your car, they can come after your car. But if you sign in your business name, and only in your business name, and God forbid you have to wind up your business, the entire lease, when your corporate entity is the party, is the only party they can go after. So if you have no money, that's why an LLC is important. Limited liability. They can't go past that. All right, so premises. Always, always, always read the premises paragraph, because it says most likely that you're going to accept the premises as is, which means with all defaults. I mean, with all faults, with all defects. So you really need to inspect the property to ensure it's satisfactory. I think something better is this adjusted language where it's delivered to you in a good and clean and tenable condition, with the systems working in compliance with all laws. So that protects you in later when, the air conditioning doesn't work. You say, well, you were supposed to deliver the premises this way. Also, if there's a work order that you want prior to the commencement date, prior to moving in, you have to include that in the as is. You're not accepting it as is. You're accepting it pursuant to the work order, and the lease isn't going to start until that work in that work order is complete. Okay, next slide. Okay, so the lease term. So this is really important because it describes the length of your lease. So these dates, you can read the definitions, but the biggest thing for the lease term is that you protect yourself, and you think to yourself, is this a new business? Am I going to be tied to this lease for 10 years, 8 years? Is it a 5-year lease? For new businesses, I always recommend a 3-year, because I think that that amount of time is valid and doesn't keep you on the hook for years and years and years if, God forbid, your business goes, south. And I do believe that the lease term, it only starts when you move in. The commencement date obviously is when improvements start. And once you move in, once you occupy that property, that lease is effective. So that means that if you agree to move in while they're doing the improvements and they don't do such a good job on the improvements, you're still liable under the lease. All right, next slide. Okay, so this is a little tidbit. I was speaking to someone in my office about, he's a commercial broker, and he said what's happening now is that in these times when you're currently negotiating a new lease, people have been tying the commencement date after the second stay-at-home order is lifted. And you're like, Meg, there isn't a second stay-at-home order yet, but there may be. So it's contemplating that second spike. And so what it's saying is that I don't owe rent, and maybe I'm allowed to terminate if the construction isn't able to be completed by the time the second spike is done. So it's just forward contemplation so that if there is a second spike, you're protected. All right, next slide. So negotiating the lease terms, this is my favorite. I love the back and forth between what everybody needs. So when you call and you say, I'm a flower shop, I'm a restaurant, the lease needs to work for you. What I did for another, client doesn't matter. Their business was different. So how do you protect your business? What do you need to run your business? And what happens if you can no longer run your business? How can you best be protected? So move forward. So the first term is in a lease that I look at is the use of premises. So what are you allowed to do? Let's say you are a floral shop and refrigerators aren't allowed in the space. You're not going to be able to run your business. So the first thing is to make descriptions general. So it should be floral shop. Just so let's say you want to sell fake flowers, you can expand your business and avoid prohibitions. I know this sounds silly, but it's happened before in my leases where someone expanded into a different business and they were prohibited. So the next thing I would say is really important for restaurants and for some specialized retail stores. It's called an exclusivity clause. And it's what you can prohibit your landlord from doing. So what it does is it says, I sell sub sandwiches and I'm Jimmy John's. And I don't want Subway, and I don't want Quiznos, and I don't want any other places like that in the strip mall where I'm renting from you. So what it does, it actually benefits the landlord because it makes you successful. It limits the competition, but you have to spell out what happens if the landlord violates it. I mean, if you just say there's an exclusivity clause and you can't do anything about it, that's not so good. So you need to put in, we go to court and get an injunction immediately and you owe every damage for all my lost sales based on my previous sales. All right, next slide. So insurance, this is a rough one and hard to get my head around originally, but so you're required to have insurance. And usually these policies are general liability, workers' comp, and special form insurance. So general liability covers lawsuits arising from your occupancy. Like if your employee, God forbid, starts a fire, that's on you. If an invitee slips and falls in your office, like a client, that's on you. So you need that coverage to protect yourself. Workers' comp, that assures the landlord that they're going to get paid when you have to pay out all these medical costs and wages for employees. Now, special form insurance is like, let's say you're, I don't know, I'm trying to think of my former clients. I don't know, let's go back to that flower shop and you're going to sell fertilizer or seeds and stuff like that. You are going to have to build maybe a fake garden, let's just say, I don't know. And if you do that improvement, someone comes in and slips on the water when you were watering your garden, that has to cover, the special form insurance has to cover that. It's not such a good example, but I'm sorry, that's all I can think of. But terms to watch, additional insured. The landlord is going to want to be an additional insured on your policy. So he's not going to want to invoke his policy. What if he's at fault? So I'm always really careful about listing a landlord as an additional insured. It also costs you money to list your landlord as an additional insured. I always look to where landlord tries to make your coverage primary. If it's his fault and he contributed to the negligence, you shouldn't be primary. Waiver of subrogation means that you agree not to sue each other. I don't like that either, because again, what if he contributed to the negligence? Amounts, the amount's going to be different for a machining and manufacturing shop versus, an ice cream shop. So one policy could be $1 million, maximum coverage, and for a machining shop, it could be 10 million. So that's important to negotiate all these terms. Now, the landlord generally just needs commercial liability insurance. So it covers lawsuits from the ownership of the building. What if a huge facade falls off the building as your invitees coming in? Well, he didn't maintain the building, so it's his fault. And I always try and get an indemnification clause in there. And what an indemnification clause does, essentially it says, look, landlord, if you act willfully, like if you planned that to fall off because you hated the person coming in, or if you were negligent, like you should have known that the elevator didn't work because you had 700 reports, but you still didn't fix it, guess what? You're indemnifying me. I'm not paying. My insurance might start to pay, but your insurance is going to reimburse mine. A lot of things that I'm seeing right now, landlords are requiring business interruption insurance. So business interruption insurance, next slide. So usually it has to have a property loss. And it means that because of that property loss, your business has been interrupted, but it still will pay the rent. So you just go to your carrier and you're like, my business has been interrupted. It qualifies based on this term, and pay out to my landlord so I don't get sued. Now, in times of COVID, people have been trying to invoke coronavirus to physical loss of property to trigger insurance. So it's up in the air right now. When government ordered the closures, is that a physical loss because of coronavirus? So there's legislation pending in 8 states and 101 cases pending in federal courts, and it'll be really interesting to see how this plays out. Okay, next. So maintenance and repairs is a huge term in leases. The landlord is usually responsible for the building, but just like Cam, the previous question we had, what about snow and ice removal? Does the lease speak to that? Sometimes in the parking lot, are you responsible? What if your tenant falls and you look to the lease and it doesn't say anything? Whose insurance is going to cover it? It's really expensive. And the invitee is going to sue someone. What if your employee falls? Does that mean it's your fault just because it's your employee? No. It means whoever was responsible for that snow and ice removal, they have to provide the coverage for that litigation. So what happens if the landlord doesn't repair it? It just comes down to what the lease says. If the lease says the landlord has an obligation to repair an HVAC unit and he doesn't, and someone dies because it's sweltering hot, then the landlord's on the hook. What if you don't repair? If you're responsible, you're on the hook. So you really have to look to these provisions to see who's on the hook. Improvements, alterations, and additions. This is a huge one for me. So let's say, just like before, you wanted to change your business and you wanted to bring in something new and you wanted to improve the property, and your lease says no improvements by tenant. Well, so I always seek to put landlord's consent cannot unreasonably be withheld, conditioned, or delayed. So if it's a reasonable request and it's going to improve your chances to pay your landlord, that should be in your lease. Also at the outset, what about signs? What if you start putting up a sign, your landlord says, no signs. Not okay. You need to negotiate from the outset what marketing you're going to need for your property. And signs are a huge marketing, wealth for your business. They bring people in, flags, whatever you want to stick in the front grass, if there's front grass, you want to be able to do that. So you have to negotiate from the outset. No liens, that talks about if you have a contractor that comes in, you're responsible for paying them, not the landlord, and there can't be any liens on a landlord's property because it's not yours. It's his, and the contractor sues you, not him. Here's the other deal. What if you improve the premises? What if your landlord agreed? and you improved the premises, are those improvements yours? Are they his? What do you do? So at the end of the lease, what are you taking and what is the landlord keeping? It's typical in leases that if it's not mentioned, landlord keeps all improvements. So if you really want to take something with you, you better negotiate it at the outset. Okay, next slide. So fire, casualty, and eminent domain. What happens if there's a fire in the building? You can't work. What if you can work in part of your office? You can work, if it's substantially damaged, usually there's a termination provision. But if it's not substantially damaged, you still have to pay rent. It's reduced to the portion of premises that you're able to use. But how are you going to work in a smoke, stinky unit? So what you really want to do is negotiate something that says, look, if it's burned and it's uninhabitable, the lease terminates. But what if it's your fault? What if you started the fire? Chances are you're going to be on the hook for the rent, no matter what. And looking to repair and replacement, there's always a term that I like to use. I want a clause that says any repair and replacement to a damaged premises shall be to the style and level it was previously. Because what if the landlord loses his money and he's going to a flea market to put couches in the lobby and whatever else? That's not what you leased. So you want a clause that says it has to be to the style that it was previously or else it terminates. Okay, next slide. So here we're going to start talking about COVID and how that has impacted businesses now and what clauses we can look at to protect you now and in the future. So I'm sure you've heard this term recently, force majeure. It's a clause that says if there's, it was incepted for supply contracts. Like if there was freighters in the ocean that couldn't get across because of storms and hurricanes, that they didn't have to fulfill the contract. And the person that was buying the stuff could get out of it. But now we're talking about pandemics, endemics, and riots. So the parties agree to not cancel, but maybe to reschedule the obligations like rent and deliverables like windows that have been broken for mutually agreed dates, and that rent is, abated while that occurs. Okay, next slide. So this is another big one. It's really hard when you can't have customers in your business because it's been shut down to an epidemic or a pandemic that you have no money. Well, maybe there's someone who needs your space for where it is and you're able to assign it. An assignment is a full set of rights, your rights going to someone else. Sublease, they come into your premises and maybe you have some extra room and they're just going to pay you rent and then you pass it on to the landlord. So again, I like to use that lease language that says the landlord can't unreasonably withhold consent to these items. Your concern in assignment, a landlord will try and sneak in that you remain primary on the loan or on the lease. They'll say, oh, look, you signed the lease and this assignment, well, it's nice that you found someone. If they default, you're on the hook. That's always an issue for me. So I try and negotiate that out of a lease. All right, next slide. And operating covenants. These are covenants that require you to remain open and operating. But if you can't, essentially you're going to look to your condemnation clause if there's a government shutdown, and in the future, there's going to be abatement or termination clauses if you're unable to conduct business for, let's say, 90 days. Now, there's another form of operating covenant called a co-tenancy. It's sort of where you're in a strip mall and you're depending you state in the lease, I'm depending on Acme grocery store for all of my clients to come in. And the landlord says, fine, so if Acme closes, then your lease terminates as well. So if Acme closes, your lease terminates as well. That's a co-tenancy, and that's an operating covenant. All right, next slide. So this is what I've used the most in the 3.5 months since this whole pandemic started. I've been negotiating tirelessly between landlords and tenants to try and reach rent reduction or rent abatement. So when there's a reduction, it means permanently your rent is reduced to that amount. An abatement just means that sometime in the future, you'll have to pay that money back, but usually the landlord is going to say, I want you to sign an additional 9-month lease and we'll abate your rent. You can pay it maybe in 90 days. We'll start adding percentages back on. So those would be based on your inability to operate, but it's a balance on both sides because that landlord is certainly going to ask for something on the other side. All right, go ahead. So this is a big one too. Landlord, so this is being tested in New York right now. It's a neat concept, and this is a way to think about it. Let's just say you have a right to quiet enjoyment, which means you have a right to enjoy your property. But what if you can't use it because of landlord's negligence, just like that toilet issue that you said before? In addressing the risk of contagion or in addressing the risk of sanitation, it would be interesting to test that theory in courts, and it's being tested in New York. This one is being tested in New York right now. But so what we're saying is, hey, landlord, you are negligent in addressing the risk of contagion. You are inviting people in who have COVID. You don't have sanitation. This is a nightmare. I am not comfortable opening. And you show fault on part of the landlord. It's called a constructive eviction because constructively he's evicting you. You can't use your premises in the way you agreed to in the lease. So this is a new theory, and I think it'll be really telling to see how it works because it could work for other areas in CAM, common area maintenance too. I didn't think about that. Okay, next slide. Okay, so this is what everyone wants to hear right now related to negotiating your lease in COVID. These are the settlements that I have been doing. There are short-term rent deferrals with rent being deferred to be paid either in lump sums or installments with varying repayment terms. There are short-term rent reductions, meaning that they're reducing the rent by 50% and you don't ever have to pay that back for a limited time, maybe 3 months. There are lease extensions coupled with free rent. So let's say for 3 months, they're going to give you free rent and they're going to extend your lease 9 months. It's called blend and extend. Very technical. And then there's negotiated lease terminations, but it's often for amounts that you have to agree to. So I've had clients beg, borrow, and steal from their beg, borrow from their families to give a lump sum to get out of the lease. And the landlord has been taking it. So they prefer to defer rent and get paid rather than grant you to not a reduction in rent, or they want their money and they don't want their tenants go bankrupt. So they're very careful to walk this line, but they really want their rent. So often I think the biggest thing that I've been seeing is that they put additional time on the other end, but it has to be reasonable. I'm not going to agree to a 5-year extension, a 3-year extension, 2 years, 1 year. I want it under a year. And I want the reduction to be significant. I want it to be at least 50% or more. So these are the settlements that I've been seeing and successful in getting pushed through. Next slide. So how do I use all this? Like, what do I do when things happen? What should I do or what shouldn't I do? And where do I look in the lease? Next slide. So what if they sell your building while you're in it? Don't stop paying your rent, but look to the assignment clause and see if that negotiation that you did saying you can't withhold your, unreasonable consents, you can't withhold consent. All right, next slide.
Hey, Meg, I've got a question related to that.
Yeah.
Okay, just one moment. So just to dive a little bit further into that, if the building that you're renting switches ownership and your original lease indicates a specific lease renewal option, rent rates, etc., is the new building owner required to honor the renewal option that was indicated on your original contract?
No. The short answer is no. And if you bear with me, I will get to that. It's a specific negotiation that you have to have in that lease.
Okay,
so
great.
Let's move forward, and I promise to get to that.
Perfect,
and if I
thanks.
don't, I promise to answer it more fully. What if you received a letter that says the landlord's property's been foreclosed? And you're like, I guess I better move out. No. So you're gonna look, this is it, a non-disturbance clause. Okay, so a non-disturbance clause, I think it's on the next slide. Okay, so I can't believe how timely that question was. Perfect timing. So the provisions that guarantee that the tenant recognizes the new owner of the property is the landlord, and you continue making rental payments to them for the duration of the rental term when that property changes hands. But it has to say, and your lease has to contain a non-disturbance provision. Otherwise, the bank, as the foreclosure person, can kick you out. So if you have a non-disturbance provision, that's, what you need if the building is sold or foreclosed upon, that you can stay in that building past that time. Now go back I think there's a right of first refusal. I just want to go back. It says helpful tip. Let's say that you receive a letter that the landlord's property has been foreclosed, and let's say your business has been rocking and you are doing so well. Let's say at the beginning of the lease, you negotiated a right of first refusal. So you go to the landlord and you say, you've been foreclosed. I have the right as a tenant, I negotiated to buy your property, to be the first one to offer it. I'm going to buy it out of foreclosure. Now what that means is usually you're getting a building at a bargain basement price, and an attorney can negotiate that foreclosure price for you, and all of a sudden you own the building. Okay, so you'll go forward 2 slides because we went over the non-disturbance clause. Okay, what about there's damage to the building, and this kind of goes to the CAM. If it affects conducting your business, don't try and fix it yourself, but look to the termination provision. Is it so bad that you can't stay there? Is it going to cause damage to your invitees? What about maintenance and repairs? Who's responsible? And then we went over the quiet enjoyment. You have the right to enjoy your property. Is it so bad? Is the damage or disrepair so bad that you can't even enjoy the property? If so, look to your constructive eviction, your right to quiet enjoyment provision, which we would sue for constructive eviction. What about minor damage? What about like when you break a window? Usually you and your landlord, no matter what the lease says, I mean, you're gonna have to work it out, but it'll probably be on you if you cause the damage. All right, next slide. So what about when you put up a sign, your landlord says, take it down? Well, don't act immediately, but do take pictures and document everything. If there's a signage provision in your lease, which should be negotiated at the outset, then it's no big deal. You point to it and say, I have an ability to put up a sign. Also, you can sort of squeak by on an improvement, alteration, and addition. And again, that's where that reasonable consent comes in. Landlord has to have, you know, cannot unreasonably withhold consent to putting up a sign. Okay, next slide. So what do you do when your landlord is harassing you? Maybe he or she isn't harassing you for paying the rent, but what if they're just always there and they're always in the building and they always want to, you know, why is your door so dirty? Why is this messy? Why don't you clean this part? Don't ignore, don't agree, but write it down and call the attorney. And if he's getting violent, call the police. The provisions you should look to protect you are, again, that quiet enjoyment provision. If you can't enjoy the premises, it's constructive eviction. You sue in court, you get out of the lease. Notice provision. How do you communicate with your landlord? Did you agree to talk to each other in writing? Send him or her a letter and say, hey, you can't do this. I'm going to notify the police. There's an access provision when the landlord has the right to access your property. Usually it will say that they have a 24-hour notice, and it's for emergency purposes where 24-hour notice occurs to check the heating, ventilation, and air conditioning, or they have the right to access it. Usually they'll negotiate 6 months or 90 days out, 3 months out, to show the property to a potential tenant at the end of your lease. Okay, next slide. So what do you do when a neighbor's interrupting with your use of the property? Don't put up noise blocking foam or anything that'll change the structure of the premises. I've had cases like this. It's a nightmare. The landlord's claiming, you know, they ruined the property, they have to fix it, and the tenant is saying, you're not fixing it. So again, the biggest thing you can do is be an advocate for yourself, journal and record, notify the landlord, look to your termination provision. When are you allowed to terminate? And what's the use of the property? Did the person next to you sign up as a drum sales company? If they did, you knew ahead of time. If you were there before, the landlord probably has to ask for your consent. Otherwise, if he didn't or she didn't, your next step is to say, I don't have the right to enjoy my property. This is a constructive eviction. So these kind of things obviously get resolved in court with an injunction for that type of behavior to stop if it's not permitted in that person's lease. All right, next slide. What about when your business is suffering, you need to get out of the lease? Try not to stop paying rent or abandon the premises, but look to those provisions we've talked about, the assignment provision, the termination provision, and the force majeure clause. If you can look to those provisions, that's great. If not, it's definitely advisable to try and negotiate. Don't stop communicating with your landlord. When that happens, the landlord says, I'm evicting them. They're not talking to me. I don't care. I have no feelings about this either way. Bye. And that's their thing. Next slide. What about when you need to sell your business? So read your lease, because if you find a buyer, you can negotiate a buyout of your lease under the length of time that you have left. Look to the party. If it's you personally on your lease, you're not able necessarily to just transfer to a company and get yourself out. But if it's your company, the landlord can't tell you what to do. You can completely tell the landlord that someone bought me out and this is the new company. And you can look to an assignment provision, which we've discussed. Okay, next slide, please. So what about you're not using all the space? And this goes back, so a sublease is where you stay in the premises and you are subleasing less than your entire interest. So maybe you have an extra space for a desk and someone wants to run their phone business out of there, you know, and you're able to do that as long as you've negotiated that a landlord's consent cannot be unreasonably withheld. I'm telling you, that term is super important for a tenant. Okay. Here's other big lease things that a lot of landlords, when there's a lease that's probably above $15,000, when it puts the landlord in the common pleas court jurisdiction instead of a muni court, landlord's going to want a personal guarantee. Personal guarantees are rough because now you're looking at, you developed an LLC to protect yourself, but now you're going to be personally liable to someone else, to the landlord, for your business. So I think these are, I just don't like them. I don't want my client to sign them. But if it's unavoidable, any contractual obligation can be backed by a guarantee. So what I like to do if a landlord's requiring a guarantee, personal guarantee, I limit it. I limit it to the part of the obligation. So maybe I'll say my client will pay 2 years on the lease max when there's 10 years, total in the term. And if there's less than 2 years on the lease, my client is not liable personally for anything. I'll cap it to a specific amount. I'll say, we'll pay $10,000 and that's what you're entitled to personally. You can limit it in time. You can have specific methods of notice where you as the tenant have to say, look, I'm facing bankruptcy. I think we may want to limit this personal guarantee further because I'm losing everything of my own, personally. That's a whole nother, I could go on with personal guarantees for a very long time. It's a whole nother topic, but I'm limiting it to what can be negotiated to protect you. All right, please, next slide. So what do? Even though you signed the lease, and the landlord can go after you personally if the business goes bankrupt, you can always negotiate your way out of it. You can always look and see first if it can be invalidated. Maybe it's not a good guarantee, or we can negotiate the amount owed unless it was an agreed to limitation in the first place. All right, next slide, please. So what makes it valid? So it has to be in writing. It has to be signed. If there's a secondary liability person, mom, dad, whoever else is required on it, that they've signed it and that they're able to perform, and consideration. So meaning if there's consideration is payment, or that you started the lease. So if you started the lease, you're legally bound under the contract if all these things are satisfied. All right, next slide, please. So this is a big part of my business right now. I want to look to invalidate the personal guarantee. What if the guarantee was part of a larger transaction? Like you had 4 different stores and the contracts for the other stores were never signed and it was pending on those other stores. Then I can invalidate it. What about if it was secured over specific property like equipment and the equipment doesn't exist? Hopefully, if there's not a lien on that equipment, I can get you out of it. If there's no other form of security that can be identified as a substitute. So if there's another form of security, then usually the guarantee will transfer over to that. Each of the parties have operated under a common mistake where they both believe something to be true, but it wasn't. Maybe you never owned the equipment because you didn't know that there was an outstanding lien on it or something of that nature, that person was primary. So where there's a common mistake, that can invalidate the guarantee. Economic duress is a really high standard. It means literally like they put a gun to your head and said, sign it or else. So you have to prove that you had no way out but to sign the personal guarantee to get the property. So the biggest thing is just to negotiate the amount down, and that just is back and forth between if I can't invalidate it, I just negotiate. All right, next slide, please. So other big lease things, tenant default, this is huge. So what's a default under your lease? Yeah, it's unpaid rent and other damages, but it also can be violations of things in the lease like use. If you use the property inappropriately, if you alter the property inappropriately, if you sublease without permission, if you don't comply, if you sell drugs on the property, you can be evicted. It just comes down to that. If there's a noise ordinance that you've been violating consistently, you're in default. And your landlord can be held in default too for the reasons we've mentioned previously, but this I'm talking about from tenant's perspective. Next slide, please. So what can you do to get out of default? You can ask for a sublet or an assignment, and you find the tenant to take the space. Again, that you have to make sure that your landlord will accept. All right, go ahead. Next slide, please. What if you can't find anyone? You can cure, which means you can negotiate a settlement with the landlord, or you can be served a 3-day notice and the landlord can evict you. Next slide, please. So what if you receive a 3-day notice? Look at your lease. Are you actually in default? If you're not actually in default, then you can fight the eviction. When does your lease expire? If it expires in the next, 3 months, really wouldn't sweat the eviction. They're going to keep your security deposit and probably not sue you for damages if you kept the property pretty nice. So be done. Did you pay a security deposit? So is there a reason out of your control and your lease has the clauses that we talked about? Maybe you should try and fight it. So the biggest thing that I see is that you have to keep communication open and be open to resolution. Do not be scared to make an offer when you're already in default. Usually the landlord would be really happy to take a payment, even if it's not full payment, because evictions are expensive and they're time intensive, and landlords don't feel like dealing with attorneys. They want to, be able to do things on their own. So that's my advice about what you should do. Next slide, please.
Hey, Meg, can you hear me?
Yeah.
Okay, great. I do have a follow-up question. Well, it's not necessarily about eviction. It is one more thought around being a tenant of a building that has been sold. The question was posed essentially that if a lease you sign with owner A says that if you decide to renew your lease, the new rent rate would be $800 a month. Before you renew that lease, the building now belongs to owner B, and owner B says the renewal rate is $1,200, not $800 a month, which was not the original renewal option. What is your recourse?
Depends what the terms of your lease are. You have to look and see what it says about a new landlord taking over. If the lease is silent to that, your best bet is to negotiate. If you are not able to negotiate with that landlord and they purchase the property, it's their property, and you were notified that it was taken over, and if your lease is silent, you're obligated to pay that rent. Or the biggest thing I do have to say, and what everyone forgets in that scenario, is that you have leverage. Your leverage is that landlords typically want to purchase spaces that have 90% plus occupancy, right? So if they have that occupancy, they don't want to go look for a new tenant. And they're more likely, if that tenant starts balking and saying, I'm not paying this, that's pretty strong leverage, and saying that they're going to move out and leave, whatever percent of that space vacant.
Meg, if you don't mind, I have a follow-up to that, if that's okay.
Yeah.
It is, right now, Lakewood is a really hot market, both residential and commercial. So I guess a question that I have is, what kind of a leg does a tenant have to stand on when a lot of these property owners probably feel pretty confident, rightly so, that they can go out and get somebody else? So I think some of them are somewhat fearful of complaining too much or making too much of a stink because either the lease terms aren't strong enough in their favor or the market conditions are such that they want to remain in Lakewood, and so it's in some ways easier said than done to try to get out of the lease, because then where would you go that you'd be able to pay, say this $800 where everywhere else is only $1,200 a month? How should they react to that?
Okay, so where you're going to look in your lease, you're going to look for your rent provision and your term provision. So the basic rent and timeline sections of your lease make the amount of rent clear. The landlord can't change it unless it's written into the lease. For example, like there's an adjustment to his or her costs and the lease allows that. Once your lease is expired, then your landlord is, are they raising your rent in a tenancy at will where both of you can leave? If you still have time on your lease, that's a litigation. That's clearly in the area of litigatable events. If there's a rent adjustment provision, you're going to examine whether the landlord's allowed to raise your rent for increased property taxes, operating costs, transfer. I mean, if the increase is unreasonably high, that's another reason, to challenge that amount in court. And renewal, like if you have a renewal option, you're going to see if you have an escalation clause. If you don't, then you have grounds to fight it. If there's not a clause in the lease that, if it says landlord can sell the property and new landlord can make whatever, I can't imagine that would be in a lease, but new landlord can make rent whatever he or she wants it to be, and you sign that, you're stuck, even if you have time left. But if you have time left and new owners coming in and raising your rent, that's litigatable. Absolutely.
Understood. Thank you.
Okay, cool.
Okay, Meg,
Yeah.
we have one question that I just want to make sure we get in, and it kind of goes along with this thought process. When people are renewing leases, we were asked a question about what if we renew our lease verbally, not signing a new document? Can you talk about renewing your lease and what you should and should not do, and maybe talking about verbal versus signing a new lease?
Sure thing. So I've litigated oral leases and I've litigated written leases. Oral leases, it's a he said, she said, so it's always advisable to get in writing. But look, if you negotiated rent at $2,000 and you've been paying $2,000, guess what? You have a contract for $2,000. And it's going to be really hard for a landlord to say, oh, I meant $2,500. And the tenant's like, no, you said $2,000. I've been paying $2,000 for 6 months, and there's record of that in all my checks. Always, always, always advisable to do an amendment to the lease or a lease renewal, like a clause contemplated in the original lease. But if there's been an oral contract established, you can always put it in writing after. But oral contracts are, as long as there is offer and that tenant has accepted it by payment, that's consideration and you have a binding contract between the parties. Does that answer it?
Yes, thank you so much. And then I have another question here that says, what if my landlord requires me to sign an estoppel certificate? What are the ramifications on that? And so sorry if I butchered that word.
Not at all. Estoppel. You got it. So an estoppel certificate just says, look, I'm a tenant in this building. I pay rent. It means that it's putting you kind of on notice that your landlord's shopping the business around, the building around. And what it does is are there repercussions? If it's specifically asking you what your rents are and things like that, yeah, they know exactly what you're paying. They know exactly what your percentage increase is. They know what they're on target to make. They can forecast, if you're paying 2.5% increases a year and they keep you as a tenant, they know they can increase your rent by 2.5% a year. So is there a danger to it? No, it's just a sort of a favor you're doing to a landlord saying, yeah, I'm a tenant here. I'm certifying that I'm a tenant here. This is what I pay rent. This is how long I've been here. This is what my business looks like. It sort of paints a picture of the occupancy of the building to the prospective buyer. Does that answer it?
I believe so. If it didn't, David, let us know. We are now caught up with questions, and I know we're nearing the end of the presentation. So if anyone has a last-minute question, please let me know before we start to wrap this up.
Okay. So this is a huge deal. This slide. Can your landlord lock you out if you're in default? And everyone's like seen the old movies where they're like, oh, I'm taking all their stuff. The landlord can lock you out in Ohio. It's called self-help. But they have to do it when you're clearly in default, where your written lease clearly allows for it to happen, and the landlord has tried to get you to cure, but you haven't. They can't do it while you're in your office during the day. It has to be at night when you're not there. That's disturbing the peace. And they can't control the ownership of your stuff. You have to be able to get it. So if they start taking your stuff, it's a push because you're going to sue them for your stuff and they're going to sue you for the rent you owe. So it's sort of, if you know what a dealer push is, where both of you have kings and the dealer wins, landlord's going to win on that one. All right, next slide, please. So is the landlord going to come after you for damages? What should you consider? Well, does your business have money? Transfer that money, get it out of the business, and show that you're not solvent. If you have other locations with that name, I can advise you on what to do. Is there a guarantee? The personal guarantee that we talked about, what are we going to do? Are we going to invalidate it? Are you going to make a lump sum offer? Is the guarantee valid? Have you been, has the landlord mitigated his or her damages? They have to relet the premises. So the second they relet that premises, you're off the hook for the rest of the rent, but the landlord can collect and ask the court for interest on the rent you haven't paid, late fees, attorney fees. And if there's an attorney fee clause, you're going to be responsible for all the lawyer's attorney's fees because they wouldn't have had to bring the lawsuit but for your actions. So solvency is a big issue, and I advise a lot of clients on that during COVID. We've transferred a lot of assets into different people's names, and that's something that I can certainly help businesses with. Next slide, please. So usually commercial leases set forth the damages. If there's a net lease where, remember, it's like you own the building, they can recover for a lot more. Property taxes, insurance, utilities, maintenance, and repairs. This could be hundreds of thousands of dollars for a big business. The lease can grant them to recover the cost of releasing the premises. So if they have to stick a for sale sign, they can charge you for that for sale sign. They can charge you for real estate commissions that they paid on getting that to a broker, renovating it, altering it, so the damages to the premises. What about if the lease has an acceleration clause, meaning all the rent's due? So they have to relet the premises, and then that acceleration clause is stopped, but they can recover all the rents and all those amounts up until that time they relet. And again, the attorney's fees, they're going to come after you if there's a clause in there for the attorney's fees and you're solvent. All right, please, the next slide. Oh, so do they have an obligation to mitigate damages, and what if he or she doesn't? They do have an affirmative duty to mitigate their damages. They don't have to accept any replacement tenant. They just have to be reasonable. So Joe Schmo off the street, if Joe Schmo has had 3 evictions against him, but he wants to lease the premises, landlord can say, And you landlord can sneak it in that says they don't have to mitigate damages at all. And then you're responsible for the entire rent up until the end of your term. So next slide, please.
So sorry, Meg, if you asked us to advance the slide, we're doing that right now. We had a bit of a little...
No worries.
It's been a day for the webinar, so sorry.
You guys are amazing. Stop.
Okay, so Ian's
Okay.
back at it now. Cool.
All right, cool. So to sum it all up, before you sign a lease agreement, if you want to do it on your own, make sure you know the terms. Otherwise, I highly recommend when you are signing a commercial lease to hire an attorney to negotiate on your behalf. Consider the amount of rent. These are just the basics that I'm telling you. If you're going to do it on your own, make sure you can pay for it and look at the length of the lease. You're not going to want to tie yourself to a long lease. Your business may grow faster, so negotiate a renewal option, right? You can always renew. But I think a short-term lease with renewal options is safe for tenants. Think about the physical space. If your business requires modifications, adding things, taking away things, make sure that you're able to make those changes. Remember the use. For the flower shop without the refrigerators, you can't work without refrigerators as a florist. So make sure your use of your business is contemplated. Less conspicuous items in the lease are crucial. If you have your camera repair business and you depend on walk-ins, make sure that you are allowed to put up that sign. If you're counting on the only sandwich shop, just like I said, your Jimmy John's, you don't want Subway, make sure that you can have that exclusivity clause. Next slide, please. Here we go. These are the majors that you should look to. Are there renewal options? What's your lease term? Rent and escalations, how are they going to be computed? What is the landlord basing this rent on? I want to know. You are so in your right to ask, and the landlord absolutely should be forthcoming. And it would raise a red flag if the landlord said to me, I base it on take it or leave it. That would be a red flag to me. I want to know what his insurance is. I want to know, what he's throwing into this rent, real estate taxes, et cetera, et cetera. A good landlord will tell you what is included in your rent. And again, the escalation is based on that grade of the building. And, Allison and Ian have so graciously said, come to us and we'll help you. Does rent include insurance? And these are things that I just said. Are you going to be charged for those separately? Is it a gross lease or a net lease? Figure it out. Security deposit, you have to be comfortable with it. What are the terms of return? Can it be used towards your rent if you default, etc.? Are the common areas included in the space you're renting? How does the landlord determine space? What if the walls are 6 feet wide, or not 6 feet, but what if they're 10 inches wide and he's charging you for those 10 inches? I gotta tell you, I'd be like, wait, why am I paying square footage on a wall? I can't use it. So how landlord are you determining the space? Improvements, who makes them? Am I allowed? What if I change my business? Am I allowed to put a fountain in if I want to show the koi fish that I'm selling for my pet store? What am I allowed to do? Fixtures, what am I allowed to take at the end of the lease? All these need to be negotiated at the outset of the lease. Specifications for the signs. I don't think a 20-foot sign is reasonable. Maybe a 6-foot sign on an entry wall is reasonable. Maybe a curbside monument sign is reasonable. So maintenance and repair, is the tenant liable? Is the landlord liable? Assignment and sublet permitted. Don't forget, my landlord shall not withhold consent unreasonably. Is there an option to renew? Huge deal. Maybe you're doing really well and you don't want to leave the space because people know where you are. Negotiate a renewal. Doesn't mean you have to take it. Termination. I forgot to mention. So you can agree in advance to terminate a lease early. Maybe they charge you $1,000 to do so, but you negotiate that ahead of time and say, look, if I'm not making, you know, $200,000 by the second term of the lease, I want to be able to terminate, and I'm willing to pay $5,000 to terminate. All right, next slide, please.
And then we do have a question.
Yeah.
And today, Tanya, what's a good lease length to sign? 3 years, 5, 8? What would you recommend?
What's your business? Does the person want to type in?
It's retail. I know who asked it.
Okay, so it's retail.
It's, like home goods.
So how's the home goods business doing? Is it doing really well? If you were, you know, if you have your forecast of your business, it's always good to sign a longer lease so you're not subject to move, especially if you're going to put improvements in the property and, you know, invest in the property. I'd want to be assured that I have that space for 5 years. But if you're a new business and you're just starting out, and you're not sure, you can always do a 1-year lease. You could do 2 years, 3 years, but I wouldn't really, for a new business, I wouldn't really go over 3, and I would do a 3-year renewal term possibility. But for an established business where you're putting considerable amount of money into the space, 5 years, 8 years, 10 years, 10 years is the max, unless you're like if you're a government entity or a huge corporation, and it would cost, if you don't own the property outright already, and it would cost a fortune to relocate. 20 years is not unheard of.
Okay.
Does that answer?
It did. Yeah, go right ahead.
All right, so the most recent PPP information from June 8th, this is for new PPP. So the portion that must be spent on payroll is now lowered to 60% from 75%. 40% of the loan proceeds can be spent on non-payroll items now, including the rent, mortgage, interest, and utilities. It revises the time for businesses to spend the loan proceeds from 8 to 24 weeks. So that's a lot more time now. It's like 6 months instead of 2 months. And increases the minimum loan term, though, from 2 years to 5 years for new loans. And it permits businesses seeking loan forgiveness to defer payroll taxes, which is a nice plus without penalty. It gives an additional 6 months to rehire those employees or restore payroll levels without incurring a reduction in the forgiveness amount. So it extends that safe harbor provision. It was supposed to be, you know, end June 30th, and now it's December 31st. So it provides exemptions when an employer is unable to rehire that employee because of COVID orders or other circumstances you just have to explain. So I just wanted to keep everybody updated on the latest PPP information. If you get in spending your bills, the only place where it affects the new PPP loan is it increases that minimum loan term, but everything else applies to your current PPP. I'm sorry if that was confusing. And the next slide, please.
Fine.
Oh, thank you. I am so grateful to you, the audience, LakewoodAlive. A special thanks, Ian. You've been amazing. David Stein and Allison Urbanek for allowing me to present to you today. If you need to talk to me or you have questions after you've thought about this presentation, please call me. I'm here. I will answer. I always return calls within 24 hours, and I'm here for you. So thank you so much. This has been, I'm grateful, and it's been a tremendous honor.
Well, Meg, thank you very much for joining us. We appreciate it. Thanks for helping us out. This was a really good discussion or presentation, and so I think it's some great questions. A lot of folks have so many questions around these terms, so thank you. We'll make sure to share this presentation with everyone, and it was recorded. Please also feel free to reach out to me. My contact information is on the screen right now. Hi, Andrews at LakewoodAlive.org, or give us a call, 216-521-0655. You can also hear our partners, Patty Ryan of the Chamber and Caitlin Milius, the Planning Department at the City of Lakewood. So, folks, thank you very much. We're going to end as we are at about 11:25. Meg, thank you very much. We appreciate your help and your guidance. You've been wonderful to work with and helped out some local merchants already. And friends, please reach out to us if you have any questions. Look for a follow-up email, and we will talk with you soon.
All right. Thanks
everyone, and have a great day. Thank you, Meg.
Okay, bye-bye.